For however laudable its intent, C-444 emerges as yet another variation of a conservative crime bill that attempts to deal with crime, as the member for Red Deer himself acknowledged at the sentencing stage, after the crime has been committed, after the investigation has been carried out, and after the offender has been arrested, tried and convicted. In other words, Mr. Speaker, after the very fact that it seeks to prevent, and regrettably, after it is already too late.
The amendment would make personating an officer for the purpose of committing another offence an aggravating circumstance. I'd like to thank the honourable member for Oxford for seconding my bill. As you know, he served 30 years with the Woodstock Police Service in his past life, and 10 of those were as Chief of Police, a great Canadian who continues to proudly serve our country. I was moved to research and table this bill following a horrible crime that took place in my riding. Flashing lights and a police uniform were used as weapons to abduct a 16-year-old girl. She had just earned her driver's license and was driving alone, as many of us do. She was held captive for 46 hours and brutally assaulted before she managed to escape from her attacker. She was brave. She survived. The offender was charged, tried, convicted, and sentenced with 6 offences, one of which was Section 130 of the Criminal Code, which deals with personation of a peace officer or public officer. The cold fact of the matter was that she was abducted only because she thought she was doing the right thing. When confronted by someone she thought was a police officer, she did what she had been taught to do. She stopped and she followed instructions. And in this case, she ultimately lost any opportunity she might have had to protect herself. This is one case that happened in my riding, but unfortunately this is a crime that is occurring in all regions of Canada, and most often it is for the purpose of tricking a victim into thinking that they are under the control of a real officer so that another crime can also be committed. When I began researching this issue, I found that what had happened in Penhold and Red Deer is happening in small towns and large cities all over Canada. Criminals are using authentic police lights and dressing in police uniforms to commit crimes such as auto theft and fraud in Kelowna, highway robbery in Oakville, Barrie, and Brampton, assault and robbery in Ottawa, abductions in Scarborough and Calgary, break-and-enter and subsequent assaults in Sydney Mines and Oshawa, intimidation in Mississauga, unlawful confinement in Lethbridge, and fraud in Kings County, Brantford, and Toronto. Mr. Speaker, for the young woman in my riding and all of these victims, the police uniform no longer represents safety and security. With time, they will cope with this fear and will hopefully regain their trust and authority. But every time we hear of these types of incidents, one more person has this trust shattered. This is a concern for all of us, but it is a great concern for police who are out there trying to do their jobs. The police that I have spoken to in my riding, RCMP veterans and serving members, have encouraged me in my mission to add this sentencing provision to Section 130. It would not affect their enforcement of the offence, but they recognize that this amendment would help ensure that sentencing for this crime reflects the significant impact that it has on our country. There was a case in Calgary where a man personated a police officer and used flashing lights to attempt to pull over and abduct young females. CBC News quoted a sergeant with the Calgary Police Force who stated that the false representation of a police officer was a very serious offence, and he went on to say, "We cannot have our confidence in the public eroded. It is very important that we are able to conduct our jobs. And if people do not trust the police or they are worried, it can make our jobs very difficult." As you know, Mr. Speaker, I previously introduced this bill during the last Parliament. It had been reported back to the House from the Standing Committee on Justice and Human Rights. The unanimous support that I received from the House was extremely encouraging, and I look forward to that same level of support from this Parliament. As I describe the specific points of this bill, let me start by explaining the definition of peace officers and public officers in the Criminal Code. The Criminal Code defines peace officers as Canadian officers of customs and excise, immigration, corrections, fisheries, and the Canadian Forces. It includes pilots in command of an aircraft, mayors, wardens, reeves, sheriffs, justice of the peace, and, of course, police officers. A public officer is defined as an officer of customs or excise, an officer of the Canadian Forces, an officer of the Royal Canadian Mounted Police, and any officer while the officer is engaged in enforcing the laws of Canada relating to revenue, customs, excise, trade, or navigation. The bottom line is that these are all occupations that demand a significant amount of trust from the Canadian public. Anyone who falsely represents members of these occupations in order to commit a crime against a person is committing a serious breach of that person's trust and that of all of us. But this bill is about sentencing. It speaks to the need for tougher penalties for this particular crime in line with the fundamental sentencing principle of proportionality, which is stated in Section 718 of the Criminal Code. And this bill has a basic objective. It would make personating a peace officer in the commission of another offence an aggravating circumstance to be considered for sentencing purposes. It would add one clause to the Criminal Code following Section 130. Because it is short, I'd like to read my bill into the record. The Criminal Code is amended by adding the following after Section 130. 130.1. If a person is convicted of an offence under Section 130, the court imposing the sentence on the person shall consider as an aggravating circumstance the fact that the accused personated a peace officer or a public officer, as the case may be, for the purpose of facilitating the commission of another offence. That is all. It does not seek to affect any interpretation of the crime. My bill would simply direct a sentencing court to consider this as one factor when dealing with someone convicted of personating a peace officer or a public officer. We know that a number of factors come into play in a sentencing decision, such as the criminal record of the offender or the severity of harm caused to a victim. And aggravating circumstances are just one more factor that sentencing judges are required to consider that don't guarantee, but tend to increase the severity of a sentence. Now, there are aggravating circumstances defined in Section 718 that apply to all criminal offenses. And there are also aggravating circumstances attached to specific offenses within the Code. So to be clear, the bill seeks to add the special aggravating circumstance to a sentencing court to consider for the crime of personating a peace officer or public officer. So when we look at aggravating circumstances that apply to all offenses, one of them is evidence that the offender, in committing an offense, abused a position of trust or authority in relation to the victim. This would apply in situations where an offender has an existing relationship with the victim, such as a teacher or a coach or a bona fide police officer. However, those that personate officers do not fall into this category. Offenders who personate peace or public officers have not abused a position of authority, for they don't have that position to begin with. This circumstance in Section 718 then cannot be used, since this would apply to real police officers who have abused their position of trust. It does not apply to then those that are posing as police officers. An offender's false representation of himself or herself as an officer is intended to deceive and breach trust and authority. But this deceit is not captured by the existing circumstances that speak to these abuses. I hope that my colleagues in the House will recognize this gap in the law and work with me to fill it as my bill seeks to do. We know that adding a new aggravating circumstance to the Criminal Code is an effective way to ensure that the fundamental sentencing principles are achieved. As to the relevance of aggravating circumstances, this Parliament recently passed an important bill on elder abuse, which was Bill C-36. With its passage into law, we saw a very important amendment to the Criminal Code, adding a new aggravating circumstance to Section 718.2 to apply to any offence against elderly Canadians. So we are now seeking, with this bill, to apply this rationale when it comes to sentencing for crimes against Canadians who have been misled into thinking they are dealing with an officer but are then victimized. The sentence for this kind of malicious deceit must reflect the significant impact that the crime has on victims' lives. Victims, whoever they may be, must be assured that there will be serious consequences for criminals who have hurt them. By supporting this bill, we are also helping to preserve the trust and respect for citizens that have real, bona fide police officers. When citizens see a police uniform, they naturally trust and respect the authority that comes with it, and our laws must reflect this reality. I note that for personation of an officer, that it used to be punishable as a summary conviction and had a maximum penalty of only 6 months imprisonment. The Conservative government in the previous Parliament passed into law former Bill S-4, which increased the maximum penalty for this offence to 5 years imprisonment and made it a hybrid offence. I commend the Department of Justice for its work on increasing the maximum sentence for this crime, which came into force 2 years ago. But now we must give the courts the sentencing tool to exercise the new maximum in the most serious of cases. For 34 years, I worked as a teacher with children and young adults. And as their teacher, I shared their joys of accomplishment as well as their concerns about the future. I was always there to help them through difficult times when they had to deal with terrible ordeals, being a receptive ear to their voices, and it gave me an understanding how difficult and fragile life can be. And as a member of Parliament, once again heard such a voice, and I shared the same concerns as others in our community when I heard of the disappearance of a young girl from Penhold. Prayers were all that I could offer. No one knew why her car was left where it was. There was nothing to indicate that she would have strayed from the errand that she was on. Her parents were frantic, and our community of Central Alberta empathized while we all waited. And finally, the news broke that she had been found. Only then did the pieces of this horrible ordeal start to make sense. The weapons used by her attacker were flashing lights and an RCMP uniform. That's why the car was left there. Her trust of the uniform and the false sense of safety and authority that it presented to her resulted in the most horrendous 46 hours that anyone can imagine. The subsequent trial of her abductor forced the girl and her family to relive this ordeal. Finally, a verdict and a sentence was rendered, but two things haunted them. First, the knowledge that the crime of personating a peace officer amounted to, in those days, only 6 months imprisonment, which was the maximum sentence allowed before the passage of Bill S-4. And second, that in the commission of this crime, the weapons used to lure her into a trap would not be recognized for what they really were. She had been deceived of the trust she had in police, and the weapon of deceit was considered as more of a side issue than being the catalyst for the crime. The day that this brave young lady and her mother came to me for help was the day that I knew that we needed a receptive ear that I'd had while I was a teacher, and it was also going to be part of my job as a member of Parliament. It's my hope that all of my colleagues can recognize the importance of this bill and will see that it is worth supporting. Thank you, Mr. Speaker. Hear, hear.
Thank you very much. It must be time. That must be that time of night. I had already started with my question to my colleague from Red Deer to point the way that we are going, but we will indeed have the pleasure of supporting the government on this bill. It doesn't happen often, but in this case, for C-444, I would like to congratulate the member for Red Deer because he did not give in to the temptation that we often see with private members' business on crime bills, wherein minimum sentences are imposed, and he decided to focus on the aggravating factor instead. So I think that this bill respects victims' rights, and it also respects the independence of judges, which for me is essential to Canadian democracy. And in that context, it also seeks to adequately punish criminals. Now, what we need to understand, because for many people, this seems rather different, but it's not a complex bill. It just focuses on the notion of peace officer, which through Section 130, which already exists in the criminal code, and we're talking about someone who personates a police officer or a public officer, uses a uniform or equipment in such a way as to make the victim believe that they are a peace officer or a public officer, as the case may be, and whoever commits an offense under that section is liable to a maximum imprisonment of 5 years or a summary conviction. So what this bill does, as my colleague from Red Deer so clearly explained, is invoke an aggravating factor for a person who commits an offense by assuming a role, a false role, for the purpose of committing an offense. Now, I'm convinced that my colleagues in the House here have already heard many horror stories, like the one described by my colleague from Red Deer. I think there have been such cases in many, many ridings. I remember a few years ago in Gatineau, there were people who were personating police officers, and they were trying to collect funds. So obviously they were using the status of police officers or peace officers to try to dupe people. Now, I would say that is perhaps the kind of softest type of crime when compared with the event that was described by my colleague from Red Deer that brings about this type of bill, and I appreciate that it's someone who contacted the member, someone who had actually experienced that horror, and so it is good that the bill arises from that. In the other parliament, received unanimous consent for the former version, and I don't think that my colleague will have any problem receiving the same type of treatment for this bill. It is our intention in the NDP to support this bill wholeheartedly, and we will certainly hold interesting discussions in committee, not so much to change things, but to convince people who are listening to us of the importance of this bill, to help people understand. Now, I think other colleagues through their questions pointed this out. Now, the fact that when someone tries to take advantage of a status, a uniform for which we have an enormous amount of respect, and I'm thinking of Section 2 of the Criminal Code, where they define a peace officer. Now we're talking about mayors or justices of the peace, correctional officers, police officers, peace officers, because there are also people who come to the door in Quebec, people who come and knock at the door wearing an official uniform. Well, it kind of, people who see these people, they will do anything that these people tell them because of respect for the uniform. So when someone abuses that type of situation, well, we must ensure as parliamentarians that all these categories of criminals are properly punished. But we must ensure at the same time that the courts are allowed to do their work in a free and democratic society in Canada, based on the presumption of innocence. So in that context, a judge may hear the case. This is a hybrid offense, so it can be punishable by summary conviction, which would entail different sentences depending, and then it would be up to the prosecutor to determine that the degree of severity of the case in question, and then to hand down the appropriate sentence. And in the context of the bill that I'm commending, because we more often see private members' bills that impose things on the courts and short-circuit the work of the judge. And most bills try to tell the judge how to determine sentences instead of allowing them to do their work. And that is not the case with this bill. This bill is well crafted. So I am very sensitive to this kind of thing, and that's why I appreciated how my colleague built this case, this bill, because we can't claim to know everything in the world. I'd sure like to, but that's not the case. So I really felt my colleague's passion, my colleague from Red Deer, and all the hard work that he has done to advance this cause, and so we certainly don't want to hinder him in any way on such important questions. And he also took the time to send us the essential information we needed so that at this stage we can make a decision, because we were not necessarily all there during the 40th Parliament when he started to work on this bill. So I would like to take advantage of this opportunity to say how important this is for us as new members of Parliament in the 41st Parliament to be able to have the opportunity to participate in such an important debate. Imagine if we had said, well, luckily this doesn't happen with private members' bills, but imagine if they had said, well, we've talked about this enough, this has been going on for 2 or 3 years, and it's time for us to get it done. The problem is that there are many members here. For them, it's the first time that we're discussing this bill, C-444.
And I think it's important to take a serious look at it. Section 132, as I said, isn't covered in the aggravating circumstances that are already covered in 78. It's included specifically and attached it to the offence in 130. If someone were preparing to commit another offence, so for example, if that meant passing oneself off as a police officer to rape someone, or as a loan collector. So there are some people, in fact, well, in fact, there are attempts to take advantage of people's vulnerability. But with this kind of bill, it will put in place the tools that the courts need in order to make that an aggravating circumstance. Now, I would hope that in cases like that, the courts will, and in fact I have seen some cases and decisions rendered on certain cases, but I would say, Mr. Speaker, that those judges heard their cases, but this time, in this case, they won't have an excuse. They will have to see that as an aggravating circumstance. The fact that someone impersonates a police officer in order to commit another offense. So I'd like to thank and congratulate the member for Red Deer and say that the NDP will be supporting this bill at all stages.
The private member's bill of the member of Red Deer that seeks to increase penalties for offenders convicted of personating a peace officer for the purpose of facilitating the commission of another offence. I will be supporting the sending of this bill to committee, and I thank the member for Red Deer for once again bringing this important issue to the attention of the House and to me personally in this regard. The member for Red Deer has been engaged in this issue for some time, and his concern is as genuine as it is warranted. Because I share his concern, and indeed his outrage in this matter with respect to offenders who disguise themselves as police officers to facilitate their crimes, thereby undermining public trust in the police and other authorities, it is important that Parliament address this problem in as principled and effective way as possible. Regrettably, while the principle underlying the private member's bill is important, the bill before us is unlikely to have the significant effect that the member himself seeks or that this House would seek. For however laudable its intent, C-444 emerges as yet another variation of a conservative crime bill that attempts to deal with crime, as the member for Red Deer himself acknowledged at the sentencing stage, after the crime has been committed, after the investigation has been carried out, and after the offender has been arrested, tried and convicted. In other words, Mr. Speaker, after the very fact that it seeks to prevent, and regrettably, after it is already too late. Though to its credit, and this bears mention, it does not seek to attach mandatory minimums in the matter of sentencing. It does not seek to eliminate or circumscribe judicial discretion, and as I said, it has a laudable underlying objective. My concern is whether the particular legislation will seek the laudable objective that the member for Red Deer himself has in mind. Accordingly, while I'm prepared to send this bill to committee for further study, I expect that such further study may be less effectual than it might otherwise be, and therefore I will use the remainder of my time to set forth certain considerations in respect of this contention. First, I will examine why this bill is unlikely to increase the length of prison terms for people convicted of personating a peace officer. Second, I will discuss why, even if it did lead to longer prison terms, it would not reduce the occurrence of this crime, which is, I believe, the member's principal objective with which I concur. And finally, I will explore other measures that might prove to be more effective and which will help underpin the very principle that underlines the bill. As I said, Bill C-444 is not likely to have a major impact on the severity of sentences. To begin with, it should be noted that in cases of personation of a peace officer, Canada currently allows for sentences more severe than in many other jurisdictions. In 2009, the House unanimously passed Bill S-4, which established a 5-year maximum prison term for personation, as opposed to U.S. states like New York or Michigan, where the maximum is 4 years, or the United Kingdom, which allows only for a sentence of 6 months. Clearly, Canada's sentencing regime already takes this crime very seriously, and there is no reason to think that judges are overlooking important factors such as the purpose of the personation when handing down sentences. For example, in 2009 and 2010, a Winnipeg man dressed up as a police officer in order to gain access to crime scenes without committing any further offence was sentenced to 4.5 months. By contrast, in the case of the man who posed as an officer in the member's riding of Red Deer in order to kidnap and abuse a teenage girl, the judge handed down a total sentence of 18 years, including the maximum sentence for personation permitted at the time. Simply put, Mr. Speaker, it appears that judges have been making appropriate use of their discretion in such cases. The additional guidance offered by C-444 is therefore unlikely to result in penalties for personation that are more severe. However, even assuming this bill were to result in longer sentences for personation of a peace officer for the purpose of committing another offence, it is unlikely that offenders would spend more time in jail as a consequence. While judges may generally issue concurrent or consecutive sentences as they see fit, sentences for offences that are part of the same criminal act tend to be served concurrently, and it is difficult to conceive of a scenario in which a judge would issue a longer sentence for personation than for the offence that the personation was intended to facilitate. In other words, Mr. Speaker, if an offender receives an 18-year sentence for aggravated sexual assault, it doesn't much matter to them whether their simultaneous sentence for personation is 1 year or 2 or 5. This bill is therefore unlikely to achieve the member's legitimate objective of having people who personate peace officers spend more time behind bars. Of course, I appreciate that the member's ultimate objective is not longer prison terms for people who commit this crime, but rather fewer personations of peace officers in the first place, and that this is his principal objective, which we share. Mr. Speaker, this brings me to my second point, which is that the deterrent effect of longer prison terms has been repeatedly shown to be minimal. Therefore, even if a judge were to be moved by this legislation to issue a longer sentence for personation than they would otherwise have done, and even in the unusual circumstance that such a sentence were served consecutive to the sentence for the related offence, there would still be no reason to believe that the occurrence of the crime of personation in Canada would be reduced. As was pointed out by Michael Jackson of the Canadian Bar Association at the Justice Committee's hearing on Bill C-10, and I quote, "The evidence is overwhelming in every jurisdiction where it's been studied that putting more people in prison for longer periods of time has no salutary effect on public safety," unquote. In fact, a research summary on the Public Safety Department's own website, which compiles 50 studies involving over 300,000 offenders, finds that, and I quote, "To argue for expanding the use of imprisonment in order to deter criminal behavior is without empirical support." And that is a conclusion that has been reached time and again by studies in Canada and jurisdictions around the world. For example, in 2010, a man used a police officer's costume to commit a home invasion and robbery in Toronto. Do we truly believe that he spent the night before consulting the criminal code, poring over the jurisprudence, and parsing the sentencing guidelines, and had the guidelines been different, he would have chosen not to proceed or to forgo the outfit? Or in the case of the 2000 tragic kidnapping and assault in Red Deer, the members' riding, is it reasonable to assume that an offender who is prepared to risk the substantial penalties for kidnapping and aggravated sexual assault would have been dissuaded by the prospect of a slightly longer prison term for personating a peace officer? I suspect not. Increasing the length of sentences is manifestly a less effective way of combating all crimes, personation included. Mr. Speaker, this brings me to the final part of my remarks, in which I will propose some alternative methods for minimizing the occurrence of personation of peace officers to begin with, which is the private member's bill's objective. First, we should examine how offenders acquire authentic-looking police attire and accessories. As a member for Red Deer noted in debate on the previous version of his bill, a wide array of police equipment is available online and at security supply stores, including strobe lighting for vehicles and uniforms that can be made to look very real with very little alteration. It's certainly worth considering whether there are steps that might be taken to limit the availability of such items. Second, the government could partner with police in a public awareness campaign to inform Canadians that all police officers carry badges and photo ID, and that citizens themselves have the right to request to see an officer's identification and to call 911 for verification if they are truly suspicious. By empowering Canadians in this way, as well as by reducing the availability of authentic-looking police equipment, we would significantly limit the capacity of offenders to pass as officers of the peace. Mr. Speaker, in conclusion, as I said at the outset, I support and applaud the member for Red Deer for consistently focusing the attention of the House on this very important issue, and I will support C-444 at second reading. At the very least, this bill will serve as a statement by Parliament of the seriousness with which we regard the crime of personation of a peace officer. But, Mr. Speaker, we should seek to do more than make what is nonetheless a very important statement. As I have outlined, there may be concrete steps that we could take that would have an impact on the occurrence of the crime itself. I trust that we will have the opportunity to discuss such steps at committee and that the government will take a seriously impactful action to combat the personation of peace officers in the very near future as represented in the legislation private member's bill of the member for Red Deer. Thank you, Mr. Speaker.